Hey there, this is Attorney Dan with Attorney Stephen Liu. We've been working on a couple of estate planning cases together over the last couple of months, and I thought I'd have Stephen here come and chat with us about estate planning and what he's experienced over his 20 years of practice. So thanks for joining us.
Yeah, my pleasure.
Yeah, so let's kind of get right into it. There's something called an AB trust, and when we talked about this topic before, it was very popular many years ago, and obviously people are still alive and still have this trust. Very briefly, explain what an AB trust is and how it's not really practical or beneficial for some people today.
An AB trust was very popular when I started my practice. The main purpose of the A side trust and the B side trust is it's for married couples. So when one spouse dies, the first to die, then you split their assets into an A trust and a B trust. Alive, the person that's surviving, the person that's passed away. And the reason for that was to be able to take advantage of the estate tax, just to save on estate tax by putting the deceased side into a deceased side trust, and then you wait till the second to die. You're able to take advantage of doubling your estate tax exemption, saving on estate tax. But that exemption amount, so like tax-free, has gone up so much. So with the new bill, it's at $15 million a person. So if I use the AB trust, we get the $30 million. But then with new laws in California, you're able to still get the $30 million estate tax exemption without using the AB trust. So the AB trust is a bit onerous. You gotta, the surviving spouse has to do a lot of the paperwork to make sure that they satisfy those requirements for the IRS to recognize it as an AB trust. So it's a headache. I have a surviving spouse going, what? I didn't know I set this thing up. What? I have to do what? This is my money. And I'm like, I'm so sorry. At the time, it made sense. But with the laws change, you get all the benefits of the tax exemption, estate tax exemption, without having to set up this kind of onerous trust. So to answer your question, for those cases where it's to try to get that exemption, there's really no need. If you trust your spouse implicitly, you're like, what's yours is mine, what's mine is yours, there's no need. But in the case of blended families, let's say you have children from a prior marriage, or you're concerned that, okay, I pass away, and we call it the Barbie Ken scenario, where you go and marry, you're afraid that your spouse will marry the Ken or the Barbie, and then your common kids will be disinherited. Like basically, everything is not going to go to your kids. The AB trust can help in that case, right? Because if I'm the first to die, then my half is going to go into trust, and then I get to pick that upon the death of my wife, then that share will still, my wife can't change who it goes to after she dies. It'll go to my kids forever, right? Without the AB trust, goes to my spouse, she can change the trust, and it can go to her Ken. So the AB trust can address those situations. If they're in a blended family, I want it to ultimately go to my kids from my first marriage, then that can address that. It's no longer necessary for the estate tax savings.